So we'll resume our discussion, and I will hand it over now to my colleague, Jeremy, who will be chairing the last two sessions. So over to you, Jeremy.
Yes. I don't know if you had a chance to read the paper. The paper, I think, was a lot more detailed in discussing the various cases and texts that I used that form the basis of the presentation. So I hope that if there are any questions on those texts, that we'll have a chance to discuss them here. But I wanted to use the opportunity to do two different things. First is to lay out what I thought is a proper principled approach to using maqasid, as opposed to a kind of what I think an illegitimate use of I didn't illustrate what illegitimate uses of maqasid are, but I sort of have them in my background, in which it's a very kind of freewheeling, results-based, results-driven method of analysis that doesn't take seriously the full spectrum of data that's available. So in approaching this issue, I tried to take a full spectrum of the data, and of course, there are lots of things I didn't talk about, and some people might question my interpretation of different things, but I think that as a legal scholar working inside the Islamic tradition, which is an important qualification, if one wishes to deploy the method of maqasid reasoning, I think it's very important to do so with some kind of standards of integrity. And that integrity requires surveying the relevant sort of theological sources, as well as surveying how the historical tradition has understood those norms, right? So it shouldn't be, as one of my friends calls it, we have a store in the United States called the Office Depot. They have a red button. That was easy. You just slam on it. That was easy. You say darura. That was easy. Darura. That was easy. And so a lot of people use maqasid not as a way of reasoning, but as just to justify a conclusion, right? And that, I think, subverts the whole process. And so what we want to do is try to develop a systematic approach that is, to use sort of a Silicon Valley term, scalable, right? You want to have a method that doesn't just work for this one case, but you feel comfortable applying it in lots of others. And so when I did that, what I found is, I think when you look at the problem of affiliation and the rules governing nasab, I'll use the Arabic term, right? And then the countervailing concept called istilhaq, where a father claims paternity over a child, right? And the different rules governing these concepts. One can find a range of what I was referring to yesterday as meta-ethical values that are in play, none of which is an absolute trump card, right? So these values interact with each other in different contexts, and in different contexts, they're given different weights, right? And so I think that from the perspective of a modern policymaker who's interested in making positive law that is somehow consistent with Islamic ideas of normativity, they need to reflect this kind of complex weighing of different ethical norms, right? So I tried to make the case that, in fact, there is a tension between a biological conception of paternity and a legal conception of paternity, and that tension is not simply unexplainable by uncertainty, by biological uncertainty, such that if we are able to remove biological uncertainty, then the legal problems are resolved, because we just always follow the biological rule, right? And I was trying to say that is giving way too much weight to biology, because there are other values involved as well. And so those were, as I tried to say, the well-being of the child. Lots of times the child is just better off not knowing the reality of things, okay? And so there's like this verse in the Quran, لا تسألوا عن أشياء تبدى لكم تسؤكم, right? So don't ask about things that if you found out the truth, it's going to harm you. And in the literature, the anecdote, one of the anecdotes that's reported surrounding the revelation of this verse was a man asking about who his father was, right? So there's a certain kind of practical benefit in not looking too closely sometimes, right? And so I think that needs to be reflected in legal rules about privacy and about when we're going to allow challenges to paternity. And so that's reflected, I think, in the very restrictive conditions under which traditional fiqh allowed a husband to accuse his wife of adultery, right? There's nothing in the verse that places any of these conditions there. So the verse just says, if a man can accuse his wife of adultery, basically he can testify, he can do this, but there are these, you could imagine them interpreting the word shahada metaphorically, right? But no, they said, no, it has to be just as a third-party witness would have to testify. And then also the same thing that immediate cessation of sexual relations, and then if he wants to negate a pregnancy, he also has to ascertain a prior, absence of sexual relations, et cetera, right? So I was just trying to show then how biological paternity is balanced against well-being of children, against the value of privacy, right, and a good name. And so these different ethical values are at stake in all of these different rules. With that background in mind, then we can start asking, I think, intelligently, well, what role should DNA play in all of this? And so I concluded, some people might disagree, I expect some would, that it shouldn't play much of a role, because most of the classical rules are not driven by, sort of concern about a lack of certainty about biology. They understand oftentimes that the rules are contrary to what we know about biology, right? Quite explicitly. So it's not a question of fixing ignorance. It was a normative determination that in these cases we're not going to care about biology. And so what I suggested was that, the illegitimate child in modern circumstances, because there's no free slave distinction, that this is really a place where it could actually do some good, but at the same time, I would just be careful and not awarding paternal rights. So I was suggesting recognizing a distinction between liability and rights. In the classical tradition, they didn't go that way because they found it very hard to imagine a situation where a man was liable for the obligations of a child, but then didn't receive reciprocal rights in return, reciprocal duties from the child in return. And so since they couldn't imagine giving both, they gave nothing. And in my opinion, that's it's too much deference to formalistic reasoning. It's perfectly plausible in my mind that you can impose liabilities without reciprocating any rights in return. And so I think that would be a perfectly acceptable, desirable move by a legislature in a Muslim majority country to say that, a man that impregnates an unmarried woman is going to be liable monetarily for the well-being of that child until that child is 18 or whatever, right? Without necessarily recognizing that child as the father, biological father's son. The other thing I was suggesting is that also based on a maqasid analysis, that instead of DNA analysis, Muslim countries can revisit the prohibition on adoption. Unfortunately, the prohibition on adoption has become this big line, ideological line in the sand. It carries a lot of symbolic weight about Muslim identity that I don't think is justified by a reasonable reading of the revealed sources. And so I tried to mention a little bit why that's the case in the paper. But I think if you look at the pre-Islamic Arabian practices of adoption, they have nothing to do with the way modern adoption is practiced. Most importantly, it had nothing to do with the well-being of the child. It was all about the well-being of the man who was adopting not even a child. In most cases, the person being adopted was already an adult or almost an adult, right? And so I make the argument that actually the pre-Islamic Arabian practice was subversive of the well-being of children because it reduced the incentive to invest in the well-being of your particularly male children. The other interesting thing I found out was it was very, I guess you could say, patriarchal practice or patrimonial practice in that females were never adopted. The only people that were subject to adoption were men, right? So it was a way for a man to continue his male line or to strengthen his male line, right? Anyway, so I think that would be a place for Muslim majority countries to reconsider. It is valuable because that way you can maintain your policy of wanting to deter zina. Right? If you have a real adoption alternative, then you might not even have you can push back against this rhetoric that by forcing the adulterous man to take care of the child, that you're somehow aiding and abetting zina. So that's another thing to consider. And then also, I'm concerned that if you admit DNA evidence to prove the paternity of the male, then men might demand the right to introduce DNA evidence to get rid of responsibility for children married during marriages, which I think would be catastrophic. Now, I worry about this because I see this happening in the United States. So it used to be the common law rule was basically the same as the Islamic rule, that any child born in the context of a marriage would be affiliated to the husband, and there would be no evidence admitted to contradict that. But recent cases have overturned that presumption. I don't know what the case is in England or Canada, but I see this tendency to give biology and biological parents priority in every case. And given the reality of dependence, right, it's very likely that these concepts will filter into the Islamic world. And I worry about that because that can be very destructive to the kind of, I think, trust that's required to maintain marriages. It's already hard enough to maintain them. So if you allow, accusations of adultery whenever you want, then that would just make things worse.
I would like to introduce another consideration, that DNA tests have the capacity to disturb the Islamic social order and the stability of the family, in as much as children are automatically attributed to their mother's husband. And that many actors claim that DNA tests should not be introduced to establish paternity out of wedlock because, in that case, they should also be accepted to question marital paternity. But, well, first, challenge of marital paternity, to the best of my knowledge, is not an issue, a pressing social problem, or at least, if it is a problem, is not as pressing as the situation of the children of unmarried mothers and the situation of unmarried mothers who, for the very fact of becoming pregnant, of being able to become pregnant, are more vulnerable to all the legal and social consequences of extra marital relationships. This is one thing, which I think should be this social problem, which is also very disturbing, I think, and very threatening for the stability of the Islamic social order. I think it should be taken into account by legislators and by the authorities. On the other hand, as far as Morocco is concerned, yes, this argument is used, the argument that DNA tests may be used to threaten or to challenge marital paternity is raised by judges, for example, to resist the occasional need to solve a paternity dispute through DNA tests. But the fact is that in practice, well, the Moroccan Mudawana admits the use of DNA tests in certain, if the judge considers it fit to order a DNA test in paternity disputes. And second, DNA tests are actually being used in denial of paternity cases instead of li'an, but DNA tests are not being except for the case about which Zainab told us yesterday. They are not used to establish paternity out of wedlock.
With all of what you're saying, what I'm saying is that I don't think that it should be a binary black or white issue.
No, I mean, I just want to know your opinion. I'm not saying that you are against.
No, but again, what I want to try to say is that the decision to admit DNA should not be based solely on the question or on the assumption that biological paternity is the most important value that needs to be vindicated, right? And if we recognize that establishment from a legal perspective of the biological father is not the goal, is not the aim of the rules of affiliation, then we can take a much more nuanced approach to our use of DNA. We can use it to establish liability of a biological father for an illegitimate pregnancy, but not his parental rights, but not as give it grounds for any parental rights. So again, I make a strong distinction between obligations to a child and rights that one can claim against a child, because again, in Islamic law, the two can't be separated. A child benefits from his parents, but then has certain obligations to them as well. Right? And so the way I understand the logic of the rules is that this was intended to deter men, right? So you can have that by denying them of any benefits, but impose on them obligations. So to that extent, having DNA admitted is, in my opinion, is perfectly consistent with the logic of classical Islamic law. But on the other hand, in a democratic age, men are going to agitate to have this right. Believe me. And maybe you don't see the problem because nobody is looking. Nobody is looking, right? Because everybody knows you can't do it. But once you say you can do it, then people are going to start looking. And when you start looking, you're going to find it. I promise you, right?
I agree that it is very problematic to grant custody and guardianship to a reluctant father. I agree with you.
And so all I'm trying to say is that we can have a nuanced approach to DNA. It doesn't have to be all or none, right? It can be admitted for specific purposes, rejected for other purposes. But like, again, going to what Inma was saying, it's not value-free. You have to know very careful, you have to be aware of the kinds of values you're trying to further here, right? And I just want to be clear that in my opinion, biological paternity is not the supreme value that Islamic law is trying to vindicate. Yes, it's one, but mostly that's vindicated through self-regulation, right? The idea that people are not supposed to cheat, like in these things, and that's primarily enforced through self-regulation.
I really enjoy that. I think your principled approach to maqasid is very interesting, and I'm just wondering whether, like, how the framework you're proposing seems to me nevertheless quite complex, because you highlight how there are different goals that jurists or legislators need to accomplish when making decisions. So I'm wondering whether, how easy do you think that will be in practice to reconcile between these different goals that include, I guess, the best interest of the child, but also preservation of privacy and some value that we give to biological truth. So how simple will it be to actually apply this in practice across a range of cases? And would you be able to go a step further and perhaps help us hierarchize the different goals that you already identify as being present in a Maqasidi approach? So I'll have...
Well, in this case, I think it's relatively easy because I think the jurists mostly did a good job, right? So, I mean, I can't speak of other madhabs, but I think the Maliki school does an excellent job in weighing all these different values. And so I would always counsel start off with what you have. There's no reason to reinvent the wheel, right? You can codify lots of things that are already there. And then for specific things, like the case of the child born to an unmarried woman, you have to have a specific solution. And that, you know, I've made my suggestion that you impose obligations but don't award him any of the rights, and perhaps introduce a system of adoption that would allow him to then claim the rights of a father if he's performed all these certain things, right? But the best thing to do is just start off from what's already there and reform that, not start from scratch.
I enjoyed the presentation yesterday, and I kept thinking about it. I dreamed about it.
You what about it?
Yes, because
Dreamed about it. Oh no.
Thought-provoking presentation and idea is very interesting, and it's also timely and urgently needed to start checking these issues in our modern context. The problem is not, as you rightly put it, is paternity biological or not biological? It's much deeper than this. There is a moral world, in this case, in which the religion, or Islam in this case, painted some items or elements in it. And there is a culture and history, etc. And there is the modern technology of paternity, and I would say also the legislative framework of the modern nation states, which challenged certain items in this moral landscape or in this moral world. The challenge is, which items are we going to say that these are changeable and we can easily fix them in order to accommodate these new challenges, and which are not? On what basis are we classifying that this can be changed, this cannot, in order to have a systematic answer that can work most of the time? In most of the discussions we hear in the Arab world in specific is that going into the direction, the more we recognize DNA paternity, the more modern we look like, the more we are progressive in protecting the self-interest of the child. And I would say this is a flawed approach. Even in the West, paternity is not biological, is not exclusively and necessarily biological. With all the reproductive technologies that we have now, it's much more contractual than anything else. I make a contract with people, even if these children are not my biological egg or sperm, they are still my children. About the best interest of the child, giving the name of this father, who may have deceived the woman. It's not always that the woman made something mistake. Maybe he's a rich person who went to a village somewhere in the Arab world. He paid money for the family. She thought that she is married, but he didn't sign anything because he's such a big celebrity. He doesn't want to put his name on anything. And at the end, she doesn't have papers which she can show to the state. So she's more victim than anything else. And then he left her, and then would be for the best interest of the child to go to the court so that the child will get the name of this person? Is this for the best interest of the child? The child will be happy. Are we sure about this, that the child will be happy about this? We are not sure. We are not, maybe we will not be at all. Paying money to the lady for the nafaqah and this stuff, is it necessary that all the time this guy will pay? as a woman, maybe as a matter of dignity, I don't want to take money from him, but I still need the money. Why don't the state would do this? The state can punish this person by getting money from him, but it's me, the state, who will sponsor and fund this issue. In the Netherlands, for instance, there is money, fund from the government to the so-called single mothers. By the way, also for single fathers. If you are a father or a mother and you don't have a partner, you don't have to work full-time because you care for your children. All these things can be solved outside the whole debate that the more we go into the direction of recognizing DNA paternity, we are not. The last thing about the issue of the moral world, in the moral world, at least as outlined in the classical Islamic law, it's both marriage and biology. When they are conflicting, which one would have the more weight? Generally, it's marriage that has the more weight. الولد للفراش وللعاهر الحجر. But did this happen because we didn't have the DNA and we didn't have the certainty provided by the DNA or not? We can debate this a lot. But we cannot ignore that marriage is a cornerstone of this moral landscape. So if we are going to recognize paternity outside the marriage, then we have to know what is the status now of the marriage institution in the family. This needs to be discussed.
Perhaps the woman would prefer not to get the money from this man. So we could, again, in classical fiqh, is the obligation of the public to maintain the children of unmarried women, right? So, but we could still say that if we know who is responsible for it, he has to pay that into this general fund. I'm totally indifferent to all of that. But what I'm saying is, I think to me, there is a deterrence function in the rule, as formulated originally, that should be replicated in the modern world. And so unless you impose some sort of liability, then that deterrence function disappears. So I agree with you completely, but I never advocated for that. I never advocated for giving the adulterous father paternal rights of paternity, right? All I said is that he should bear obligations. And there's a difference. It doesn't follow that just because he's obliged to follow nafaqah that he gets the legal entitlement of a father. And I sort of want to repeat this again, but it's I think sometimes, at least the fuqaha naturally drew the inference, if you are subject to the obligations, you must get the rights, right? Because they even said, al-kharaju bid-daman. So they used that principle in family relations, which I think is a misappropriate analogy. Sorry, al-kharaj bid-daman means that the profit flows from liability. So if you own an asset, you're liable for the asset, but you get the benefits of it. So the same logic was used for parents. Because they have an irrevocable obligation toward the children, they get certain rights back from the child, right? Anyway, so I totally, that's why I'm very concerned that if you recognize paternity based on DNA, you would undermine the special status of marriage. That's why I don't want to do it.
I just have a couple of comments and then a question. I saw and I used a case from Bahrain, which actually works with what you're saying, where the DNA evidence came against the wife. And yet the court ruled on behalf of the wife and actually accepted the paternity. I'm happy to send it to you if you want it. It just fits exactly what you're saying, that this finding was exactly about that, that even though the evidence came against that this is not the father's son, basically the court said, no, it's been 11 years and this is the good of the child, and basically they committed him to pay for his support. This is one. The second thing is the question here is not about getting money. The question is about the state itself. The individual doesn't have citizenship if they don't have a father. That's the big question here. So I think the discussions that we've had yesterday were extremely important, and yeah, we need a new fiqh for all that. Because the fact is, there are all these homeless children, particularly in our great country, Egypt, but in other countries as well. There's so many homeless children today, but even more serious is the fact of the millions today that are brought for paternity cases to court all the time because the fathers refuse to to actually admit that this is their sons. Today, the numbers are growing, and it's become an actual issue. How do you so should the state be changing its rules? And basically, we had that important case a couple of years ago where a woman went and asked that the child be named after her. And finally the court decided, no, we are going to force the father to have to get paternity. So the question of paternity today is very, very important. I think the discussion we were having yesterday about alternative families is what needs to be discussed. We really need to talk about this. We are moving to alternative families, whether we want it or not. And so I don't know how you feel about this, but here's my question to you, because this is the real question I have. Years ago, you and I were in a conference in Cairo, and Abu Zaid was there, and I remember a big discussion between you and him on the whole principle of wahy versus maqasid. And well, he's gone now, but this was his new work, was on wahy. And I'm asking, yesterday as we were talking about, do we really have answers for these problems, or has maqasid run out of steam? And basically what we need is to take it up one step higher outside of this methodology and go to methodology that actually a person like Abu Zaid was trying to do, but never completed.
Well, I don't remember this conversation at all, but the problems you're talking about, there are systematic problems to maladministration in post-colonial states. Fiqh has nothing to do with them, okay? And so I don't know enough about the problems that arise out of the poor administration of Egyptian laws, et cetera, but I'm all for fixing them. But I don't think fiqh has anything to do with the maladministration of the Egyptian state, so I have no competence to speak on it. I can't imagine how the fact that a child is abandoned would allow the Egyptian state to not give the child the rights of a citizen. I mean, that's absurd. Again, if you look at Bab al-Iltiqat, Bab al-Laqit, right, abandoned children, the Laqit is given essentially the status of the place where he's born, right? So if a child is found in a Muslim neighborhood, the Muslim, right? And so that was nationality then, okay? So if you don't have if you don't know the father of a child according to the rules of abandoned children, they are assumed to be a Muslim, and the state has to take responsibility for them. That's what the fiqh says. So fiqh, if that's the issue you're worried about, fiqh gives an easy answer. You don't need to have papers to prove that you're lawfully there. If you are found on the territory, the state is responsible for you. End of story. I mean, I don't know what the Azhar says, because it's following it by probably Egyptian nationality law, that you have to prove you have an Egyptian father. But that's not what the fiqh says. It's based on where you're found. If you are found in Muslim territory, you are considered a Muslim and therefore get all the rights of a Muslim.
First, thank you for your comments and questions yesterday. For today, I would like to go back to some elements I mentioned previously in which I think there is a bit more to discuss. I would like to go back to how the two judges, in the case I mentioned, used the same article of the Mudawwana, the Family Status Code, to show radically different interpretations. So the first instance judge relied on Article 32, which establishes equal judicial protection to all children, regardless of their familial status, to support the ruling. The judge stated, however, that even if lineage is proven, the legal relationship between the father and the child cannot be recognized based on Article 148, right? So first saying that there is a need for protection, but then saying that the legal relationship is the only one that gives rights. So Article 148 rejects paternity determination for children conceived out of wedlock in favor of the legal canon stating that the child belongs to the marriage bed. That is, that paternity only goes to children born from a legal union recognized in Islamic law. In this way, the first judge drew a distinction between biological kinship and lineage, right? So that is a bit of the innovation. Two concepts that were treated as inseparable in practice. And there I find a very interesting and useful, maybe here, model for those, let's say, ethical issues we dealt with or we talked about. By doing so, the court demonstrated principles of ijtihad, so judicial reasoning, something that we see more in the Shia context. And this principle of ijtihad is also explicitly encouraged in the Mudawwana itself. Even if the judge did not refer to this legal tool by name, so she did not mention that, but it is in the Family Status Code, so as also a provision. Although classical Islamic law indeed dictates, in the case of a child born out of wedlock, that the child has no access to any of the rights bequeathed by a legal relationship to his or her father, this is in violation of the Moroccan constitutional principle of defending the rights of children. The first instance, Judge Ijtihad here allowed the court to defend some of the child's rights in accordance with the constitution without violating Islamic law. The appeals court judge, on the other hand, determined that the relationship between the man and his alleged daughter is so apart that he pretty much allowed for incest. So I mentioned that. He then moved on to cite that same Article 148, as had the lower court, to stress that the illegal coupling had no legal effect, and that would result in granting rights to the child. So here we see how one judge conceding to this provision in the article, has shown that it is there, but brought limitations. And that was through here also the obligation of ijtihad and state responsibility in protecting children, and the other judge upholding that same article as a clear legal framing that ends the discussion right there. So both are technically right. So here I think what could be insightful is to think about how a legal framing can be redesigned to push for the former and limit the latter, meaning systematically push for the judicial reasoning to survey several articles, but again, would that be enough? I also want to go back to some of the points brought to me by the attorney of the plaintiff in this case, who was obviously infuriated by the rejection of the decision. So he talked about how this is an example of a widespread practice of some careless men to hide behind the law in cases of parenthood. He insisted that the plaintiff also really benefited from her dual citizenship to get support and publicity that you would not get normally, and that goes back to that sad case of Arab nationals being disregarded in their own countries unless they have a Western connection. The first instance judge was also not an average judge, so she presented a stark difference. She is a young woman in an environment of older men and made also a lot of research. She used international convention that helped her in that case, so that is also not a common practice. I also mentioned yesterday that there is a business of trafficking of such children in Morocco. So some associations like Beigti actually did not want the first judgment because it will kill their so-called profitable business. So here too, without needing PGD and gene selection, they are able to cater to some parties and demands of, I don't know, I need a child with blue eyes, blonde, boy, girl. So here a different channel. I would like also to go back to other cases of DNA tests related to this case and that show an incoherent use of such evidence. So in cases, again, where a woman is condemned or suspected of adultery, and then there is maybe here a much easier acceptance of DNA tests. So here these double standards, as opposed to accepting the principle of children of the firash or bed.
Another point I would like to emphasize from your talk yesterday is the appeals court reference to an opinion by Ibn Hazm, which is really very, very strange in a Maliki country like Morocco, whose family code is, the authority of the family code and its connection with Sharia comes precisely from its Maliki pedigree. Apart from that, I think there was no need to mention Ibn Hazm. Any Maliki jurist would have told exactly the same. A child born out of wedlock cannot be affiliated to the Zani and has no rights to So I think these points, I don't know what's your opinion, maybe I'm wrong, but this points to certain Moroccan judges' lack of acquaintance with Maliki fiqh, which would be necessary to practice ijtihad.
Yeah, I agree. I don't know, maybe the judge was a big fan of Ibn Hazm, that's his thing, I don't know, but who knows. I think it was unnecessary, but probably it is more revealing of this let's say, understanding of Maliki fiqh in Morocco. I think that's a point Mohammed brought also regarding the fact that maybe there let's say knowledge is kept as opaque and not really opened to the wider public. So kind of having that monopoly of knowledge and that excludes judges. So yeah, I think that was not necessary and problematic, and maybe there was more need to attempt and showcase that this is rooted in, let's say, in the tradition, and that's why he, let's say, made that reference. So more showing off.
I actually thought it was very mean-spirited because Ibn Hazm's view that you can actually marry your illegitimate daughter is an extreme position. And the only reason to cite that is to show your case is so bad. But that's not even within the Malikis don't say that. But it was sort of like he went out of his way to be nasty. I mean, that's how I was shocked myself.
Yeah. Connecting your two papers and just thinking through the actual potential use of DNA testing in Muslim societies, there's a very poignant and sobering chapter that was written in a volume that we edited about the use of DNA testing in Brazil by an anthropologist named Claudia Fonseca. And once that technology came to Brazil and started to be used, for example, in a household, like a common law relationship where the couple had been together for a long time and then got into a dispute and started, berating each other and demanding DNA testing, and then finding out that sometimes children weren't the husband's, the man, and severing the relationship to the child. It was not for the benefit of the child. Children were really getting harmed in a lot of the examples that she was showing from Brazil, and just sort of the uptake of this technology in Brazil has had some profound and negative impact on family structure and relationships and so forth. So just thinking through, like, what if DNA testing comes in a widespread way to the region, how might it be used, and how, in terms of child, I mean, I see your paper, Mohammed, really arguing that the welfare of the child is very, very important, right? And in some ways it usurps, or it's more important than other obligations or sense of lineage and so forth. So that example, it was always troubling to me, and I thought, well, gosh, the Middle East, I don't think there is widespread paternity testing. I mean, it's not a technology that's really come to the region, but it sounds like the potential is there now that DNA testing is going to be used a lot. And then it made me think about the use of DNA, connecting it to other papers, the use of DNA testing in IVF conceptions when babies are born through IVF, and there's always, it's a huge fear of parents, is that there was a mistake in the laboratory. I cannot tell you how many men have told me that the thing that most worries them is that a mixing of the gametes, a mix-up would happen. And what if DNA testing started to be used regularly in assisted reproduction, people just double checking to make sure that those children are really their own? Because in India, where people have started checking on the biology of the offspring because of distrust in the clinics, they found that something like 4% of the offspring actually are not biologically related to one of the parents because of sloppy, so something like 4%. It's small, but it's still, in a huge country like India where they have more than 500 IVF clinics, there are mistakes that do happen, and then if you started DNA testing all of these kids, what would you find out, So I'm just thinking through, like, the potential in terms of harms for children, if DNA testing really starts to be used in a wider range of issues, there are some negative consequences, especially for those children, including for IVF conceived children.
I'm glad you brought that connection with Mohammed's paper, because I also wanted to actually go back to some points you raised. So I understand that let's say there are problems in the two cases, so regarding DNA test use. However, obviously a middle ground is ideal, and I like how you here present the possibilities for a middle ground, and promotes also the weighing of all the options. But I just have a little concern over the point that some may be better off not knowing the truth, because also linking here the idea of setr, right, that you have regarding privacy, which is also important. So privacy, particularly in the context of overwhelming information. But I don't think we really get a middle ground. We often end up in an overbalance anyway, right? So we tip one side or the other. And the, let's say, overbalance now is on legal parenthood, right, over biological parenthood. And the information of biological parenthood give also here, let's say, an important information that if we don't have access to it is also a form of harm, right? So the idea is that there should be the, let's say, option of getting that information, the truth, even if it is maybe not, let's say, involving the best consequences, but just the, let's say here, the access to information is something that's there. So grabbing it, right? It's possible. Yeah.
Thank you very much, Zainab. A very interesting paper, and thank you for the update on the practice in North Africa. My question goes back to something I raised yesterday about this emerging distinction between bunuwa and nasab, and to what extent you see in your research, either in Morocco or North Africa in general, you see this is I'm aware that the same distinction is made in other North African contexts as well, like in Algeria and perhaps in Tunisia. I'm not sure about Tunisia. But to what extent do you see this as a kind of a emerging kind of new trend, if you will? We've been talking about these trends a lot since yesterday. And if I may, just to follow on the suggestion by Marcia to link with Muhammad's paper, if you may allow me, I found your paper very interesting, and I appreciate the fact that you are addressing the foundational scriptural references with an effort to try to find a way to perhaps invite perhaps new investigation or readings in order to allow maybe room for new interpretation. So I see you start out by making reference to this Quranic verse in Surah Al-Ahzab, attribute them to the, and then you question the assumption that pre-modern jurists kind of had or adopted regarding the definition or lack thereof of the father. Who is the father? But I was wondering how you would kind of respond to the conventional kind of answer that, okay, the definition is given in the Sunnah, al-walad al-firash. So the Quran says, دُعُمْ لِآبَائِهِمْ, and the Sunnah says, آبَائِهِمْ is defined by firash, either in the case of free women or free men or slave women and masters. So this is one point. The other is you mentioned the limitation of knowledge. So you talk about how the presumption in the Islamic legal tradition was more in favor of the legal definition of paternity, and you mentioned that was partially, at least, or could be due to limitation of knowledge, but there were some ways that they also relied on, like for example, and perhaps actually the argument has been made. I'm not inventing this, or I'm not the first or the only one using this, but that qiyafa is the equivalent of the DNA in the modern period. So sometimes people refer to DNA as the modern qiyafa, for example. So what I'm trying to say is that there were means, practical, quote unquote, scientific or cultural ways to do that. So this is another point. I appreciated also the nuanced kind of approach you have here regarding the invitation again to balance various considerations, competing considerations sometimes, benefits of the child vis-a-vis other considerations as well. But I wonder, and because that comes also in the context of other issues, how would you define benefit of the child? Because it could be something that is arbitrary and subjective, especially if, and that goes back to the whole notion of objective Sharia to begin with, right? So how you anchor it in something that would be, established. So I have several other points perhaps I can talk about later or over coffee, but I think that would be enough for now.
Can we talk about my interpretation of Al-Ahzab later? Because it'll be complicated. I think the definition of well-being of the child is pretty objectively laid out in the fiqh. It's pretty much economic, that there has to be, at a minimum, that there has to be a definitive obligor with respect to his or her, what she's required to live. Because the problem with the kafala system is it creates a collective action problem. It says the entire Muslim community is responsible to take care of abandoned children, okay? But no one person in particular. And whoever does take care of the child is a volunteer, so they can abandon that child at any time and return it to the state. So historically, it's always been underfunded. It's not as though Muslims just abandoned children to their fate. They tried, but as you know, with any kind of public program, there's always a risk of underfunding. But when there's a legal parent, actually you can enforce the obligation against that particular person. So that's why the jurists thought that nasab is so important. So the Hanafis actually have a very interesting discussion about this, that it's ihya, it gives life to the child because there's somebody there who is a guarantor of his well-being, right? So that's why it's so critical for the well-being of the child that there's somebody with an enforceable obligation towards certain things. Shelter, food, clothing, education, right? In theory, the public can do all these things, but in practice, we know it doesn't do it, or it chronically undersupplies public goods, right? Especially in a place like Egypt or developing countries. Now, there's a second question you asked. Yes, qiyafa. Okay, I don't want to, qiyafa is physiognomy, right? Now, let's just call it science, because that's what they had of the day. What I find interesting is that physiognomy was not admissible as evidence of who the father was, right? It was purely based on firash. Physiognomy was only admissible in the case of a child born to an enslaved woman, where the master had never had sexual relations with her. So the class of cases in which the testimony of physiognomists was admissible was like vanishingly small. So that proves to me conclusively that it was not about absence of knowledge. They just did not admit it where there was any illicit relationship. And if there was a clearly illicit relationship, then, like with a free woman, then it was not admissible. It was only in the case of the enslaved woman, because there was it was important to establish the father of the child, but it didn't interfere in the property rights of the master. So it's just not, it's so marginal. It tells us that they didn't care about it.
The comments that you were making about the problems of using DNA testing, because whether the children might want to know or have interest in that information, and whether that is inconsistent with the issue of using DNA just to assign responsibility. But it doesn't seem to me that, maybe I misunderstood you. So it seems to me that it's perfectly possible to have regulations that say causal responsibility for parenting, unless you have transferred those responsibilities, like in the case of donation, for example, whomever is causally responsible for the creation of a baby has financial responsibilities, and that's what the DNA testing is intended to do. It doesn't mean that it cannot do other things or that you cannot use it in other ways, but it cannot be used to eliminate that responsibility. So you could still use DNA testing in all kinds of ways, like that. This might be a consequence of the use of DNA testing, but that doesn't mean that still we cannot have regulations that if you are causally responsible and you haven't transferred those responsibilities to someone else, you're going to have to, be financially responsible for that child.
That we should still advocate for DNA use beyond, right, that systematic tying to financial responsibility, right? Yes, definitely. So that's definitely the point I was trying also to make, because let's say here the reason was to maybe respond to fears that this introduction of DNA is, let's say, creating greater problems. So the idea that yes, maybe, but we can still curtail maybe some of those negative consequences by, let's say, enabling during the judicial process the weighing of different options, and also based on the principle that it could be maybe optional, right, rather than an obligation, but not also rejected, right? Systematically rejecting DNA use. So regarding the point of research, well, in the region. So I'm starting research, so I don't have data yet, but I hope to be in a better position to get back to you by the summer. But regarding the three countries of the Maghreb, in Tunisia, definitely DNA tests are almost routinely accepted. So there is a distinction there more clearly between Bunuwa and Nasab, and that is only emerging in Morocco. And I don't really know much about Algeria, so that's definitely needs more exploration. However, it's also very problematic in Libya. So actually the attorney was kept having, was contacted by many women from Libya regarding maybe here that distinction that was made to help them in their own cases.
Regarding the distinction between Bunuwa and Nasab, I think the Moroccan family code distinguishes formally between natural paternity, Bunuwa, I don't remember exactly which article, but there is a fundamental distinction in the new reformed Mudawana between Bunuwa, which is natural paternity, and Nasab, full-fledged legitimate paternity. And in Tunisia, there is the code does not address the rights of children born out of wedlock, but they have the patronymic name law. And with this law, mothers, unmarried mothers, can obtain financial support and a name, family name for their kids against the biological father of their children with DNA test. Okay? And so, yes, the law, this kind of paternity is termed Bunuwa. And it's not Nasab, but according to some reports, since the entry into force of this law, the rate of child abandonment has decreased quite significantly in the country. It does not solve the problem of discrimination against unmarried mothers, especially against unmarried mothers, but it seems that the law has improved the situation. The situation, at least as far as child abandonment is.
So much for a fascinating paper. I just wonder whether I've never come across the term Bunuwa. Can you clarify that? Can you clarify that? I have never heard that term. Maybe is it an Arabic word? And what does it mean exactly? Because I know it under a different term.
So Mudawana is the family status code, and I think maybe etymologically it comes from Tadween, right? Mudawana, Tadween. I think the distinction is bottom up versus top down. So lineage is top down, right? So it gives here the rights of the, let's say, family to the child, versus here it's the biological link that links the child to the progenitor. So I think
paternity is more biological paternity, while lineage is the legal kind of paternity. And I think some people at least felt the need to make that distinction because of the incoming of this DNA technology, where you have these competing kind of claims, either on the basis of biological paternity and whether it has a standing, to attribute lineage or not. So while some don't actually make that distinction, they just equate them, use them as synonyms. This is the emerging trend I was talking about. Some judges felt that, and that links again to what Muhammad was saying, to distinguish between paternity obligations and paternity rights. So paternity obligations in terms of financial support and everything attached to biological paternity. So if there is a claim against a biological father, then he should bear the responsibility by supporting, the child, etc. But he shouldn't get the nasab, which is the legal kind of, the full kind of lineage, package, if you will.
Instead of summarizing my presentation from yesterday, I would like to read a couple of legal cases, or just information about two legal cases, one from 15th century Fez in Morocco, and one from Libya in the 80s of the past century. I think these cases illustrate quite nicely what it represents for women, for Muslim women, the shortening of the legal duration of pregnancy according to the criteria of medicine. So these cases illustrate the issues that are at stake, and very especially why I think that there is a close relationship between the accommodation of modern medicine as regards pregnancy by contemporary Muslim jurists and the need to reinterpret or to review classical legal doctrine on the criminalization of zina, of extramarital relationships. Well, the first case refers to a woman from Fez who gave birth to a child 7 years after her husband disappeared in a battle. The Qadi of the city consulted, the case was reported to the Qadi by, apparently by the relatives of the husband or by the people, it's not clear. Well, the Qadi of the city consulted the case with the Muftis, with his legal advisors, and the Muftis advised him to submit the matter to a rule found in, a very well-known compendium of Maliki legal doctrine, Sahnun's Mudawana. According to Sahnun's Mudawana, according to this seminal text of the Maliki school, pregnancy lasts 5 years maximum. Faced with the implication of declaring the child illegitimate and sentencing the mother to stoning for zina, since she had been married, the Qadi located an opinion issued by a jurist, a well-known jurist known as Abul Hasan al-Qabisi, according to which the opinion transmitted in the Mudawana, in the source I have mentioned in first instance, this opinion was not only an alternative among others, but it was weak. Moreover, this Mufti, Abul Hasan al-Qabisi, invoked the need of statutory sanctions. I mean, stoning for adultery is a statutory penalty or had as much as possible. Reassured by this argument, the Qadi decided to consult with another Mufti from Fez, Abdelaziz al-Qarwi, and this latter Mufti was not part of his advisory council. This al-Qarwi told the case of another woman who arrived in Fez and announced that she was pregnant. 7 years afterwards, she delivered a child who was described as looking very much like the deceased husband of the mother. This resemblance and this claim by the mother was accepted and acknowledged by the deceased remaining children, including the newborn's right to inherit from the man. These events that tell us about, the collaboration not just of the jurists with women, but of the whole family or the whole society, these events were reported by the Mufti without objecting to them. So based on this argument and on al-Qabisi's opinion, the Qadi of Fez established filiation of the child born 7 years after his mother's husband has died. So the Qadi established filiation with the disappeared man and waived the punishment for the mother. So it was in this case, the father had not deceased, the father had disappeared, as I mentioned at the beginning. So here I want to stress the relevance of making pregnancy public as soon as possible. So in this case, it was essential for widows or for abandoned women or for wives, it was essential to declare themselves pregnant as soon as possible. Extended legal duration of pregnancy appears to have been rather effective, as we have seen, to protect widowed, repudiated, and abandoned pregnant women against an accusation of adultery. Yet, legal practice, as reflected in a number of fatwas from Al-Andalus and the pre-modern Maghreb, suggests the relevant Maliki doctrines were not always respected when patrimonial rights like maintenance, nafaka, and the inheritance rights of the unborn were at stake. Once the accustomed 9 months, 2 years at most, had passed since a woman declared herself pregnant, she could be obliged to undergo a physical examination by expert women if the ex-husband of his relatives refused to pay her nafaka any longer or did not accept her claim of pregnancy to postpone the division of the deceased's inheritance until her delivery. In case of disagreement between the expert women, a positive report of pregnancy was given preference over a negative one. The prevalence given to the positive report of pregnancy gave those women the occasion to show solidarity with a fellow in trouble. Yet, if she was unanimously declared not pregnant or carrying a dead fetus, she risked being forced to return what she had received for her maintenance until that moment. So, in those situations, knowledge of the admitted maximum limits of pregnancy was essential for women to resist pressure from her milieu or from the jurists themselves and persist in her claim. And we know that some women were very well aware of the of the legal duration of pregnancy and claimed and were successful in rejecting the pressure by their relatives and by the jurists. Well, the consequences of adapting the maximum legal duration of pregnancy, now we shift to the 20th century, the consequences of adapting the maximum legal duration of pregnancy to medical standards in legal systems where extramarital relationships are subject to harsh punishments may be dramatic. This is well illustrated by the case of a woman in Libya who gave birth to a child 29 months after divorce. At that time, the doctrine or belief in the sleeping fetus or in prolonged pregnancies had been cancelled and had been was no longer considered as a valid legal argument in the family codes of the area. So, this woman, who gave birth to a child 29 months after divorce, called to the doctrine of the sleeping fetus to attribute the child to her ex-husband, but her claim was rejected by the court. Instead, she was judged for illicit sex on the grounds of a medical report that denied that pregnancy can last that long. And I stop here. Thank you.
Thank you very much, Delphine. I think this is, so I read the paper more than, I think what you're offering today is, so my comments have more to do with the paper than what you've said today. Or I think the case is really a really good case to think about the relationship between science and religion historically, and how that relationship might have changed. Right? So I think it's a really interesting case study. One of the things, I mean, there are a number of interpretations of the sleeping fetus within, like why did jurists accept this? But I was struck by a comment that the Maliki jurist Ibn Arabi made, and which is related in one of Muhammad Ali's articles that you also quote, where Ibn Arabi accuses his fellow Maliki jurists who claim that the maximum length of pregnancy to be 9 months, he accuses them of leniency. He accuses them of being mutasahilun. I find that quite interesting, right? Because it shows a number of things, right? It shows that that opinion was present, right? And that opinion had some scientific validation behind it. And yet it was dismissed by fellow jurists within the Maliki school for being too easy. And so easy, I think, insofar as, in my understanding, it seems to privilege science, or science, it seems to privilege scientific authority over scriptural evidence or over religious interpretation. So perhaps one of the things that has changed, or one of the things that one might want to think about, is whether that relationship between the relative authority of science versus religion, whether that relationship has changed in modern times, and how. And so that might also allow us to make sense of some of the debates that you describe in relation to the scholar Al-Hajji, right? So that's one question. Has the relationship between religion and science changed, and how? The second issue that I wanted to raise briefly was you highlight how the question of pregnancy is connected to a set of legal issues, right? So nasab, idda, nafaqa, inheritance rights, and unborn children's eligibility for bequests. And so I was wondering, I mean, you focus on the kind of juristic discussions, but I was wondering whether there are also legal cases where these things have come up, and how have judges decided to arbiter these issues. So maybe the Libyan case that you were referring to would be an example. Are there other cases in North Africa or elsewhere that you could point to? Because it would be interesting to think about whether the discussions that these jurists are engaged in are more like theoretical issues that are attempts for them to think about the relevance of Islamic legal doctrines in the scientific age, or whether these are also things that appear in courts and have to be negotiated by judges and litigants and so on. Okay, so perhaps something, I mean, I find Al-Hajji to be struggling with a number of issues that you highlight very nicely. In the question of mixing of sperms, he seems to oscillate between the idea that this is just scientifically unsound, and so he sides with one group of jurists. But in the end, you also suggest that he's open to the possibility that science might actually contradict that and show that mixing of sperms might be an option. And so there were some presentations yesterday that suggested that this may indeed be the case. So I wonder whether you wanted, I mean, maybe in the future you might want to think a little bit about, like, what does the scientific evidence have to say about this, and to what extent is Al-Hajji actually aware of this? I was not entirely sure if whether he, I mean, he seems to, he's a doctor, right? He has some medical expertise.
I don't think so.
No?
He's medicine, but I think he's just a scholar.
Okay. And perhaps, I mean, if you could say something about whether he's also, to what extent he's also connected to the legal process and the medical field, that would be interesting. Thank you so much.
I don't think, well, this statement by Abu Bakr ibn al-Arabi is very, very, very interesting. The question there, I don't know which was the opinion of Abu Bakr ibn al-Arabi regarding medicine. I don't think this statement has to be understood as a rejection of medicine or of the natural sciences. We have to take two things into account to understand or to put this statement in its right context. First, he was a Maliki, very convinced and charismatic Maliki jurist, so he simply abides by his school doctrine, according to which the maximum duration of pregnancy is 5 years, 4 or 5, it depends on which opinion you follow. Second, what he says, what he implies when I think when he accuses his fellow Malikis of being, not taking the issue seriously, is because, yes, he thinks that the legal duration of pregnancy is not just simply a medical issue, but one has to take the whole doctrine into account. That is to say, affiliation, accusations of a possible accusation of zina, and the need to protect the Islamic social order at any cost. Well, not at any cost, but as much as possible. So if the school doctrine has agreed that pregnancy lasts 5 years, he finds no need to question this. Third, and I think this is the most important issue and factor, he was a staunch opponent of Ibn Hazm. They were not contemporaries, but he was attacked very ferociously by Ibn Hazm's followers in Al-Andalus. In fact, he dedicates some space in his books to reject Ibn Hazm's ideas from a theological, a legal, linguistic, from all points of view. So I think this statement has to be understood in the sense that he was terrified because at the prospect that his fellow Malikis were going to adopt Ibn Hazm's position, or the 9 months or 1 year duration. And he was terrified that Ibn Hazm and his followers got some credit through this move. And he had sound reasons to think like that, because, as I said yesterday, Ibn Abd al-Hakam, who was a Maliki, held that pregnancy cannot last more than 1 year. So within his own school, there were some deviants, between Marx Maliki. So I think this statement has to be understood in that sense and not as a rejection of the natural sciences and medicine. So it's contextual, and this points to the relevance of knowing the context and the circumstances of this. Well, I gathered information about judicial or legal cases in the pre-modern times. I didn't, because, well, I have collected a lot of opinions by contemporary jurists, and I didn't have time so far to collect information about present-day legal cases in which, yes, women try to abide or to call the doctrine of the sleeping fetus in their defense, even though the doctrine is no longer legally valid, or is not longer a legal argument to explain a prolonged pregnancy. So yes, it would be very interesting to do that. I think Noël Collin, this French anthropologist who wrote about the sleeping fetus, has collected a number of, well, contemporary, they are not very recent, but although this would be another paper or another research, which of course I plan to do in the future. Yes, Al-Hajj's position. Well, yesterday I think I was a little bit harsh with him, saying that his attempt to explain this Ikhtilat al-Ma'ain or Ikhtilat al-Ansab doctrine seemed to me a tactic to evade the task of reviewing this doctrine in light of biomedical progress. But, well, on the other hand, I must say also that he's the only one to address this thorny, this delicate issue directly. He's the one who takes the bull by the horns. And this is and he's to be thanked for that, because he's going much farther than his peers. But, well, this, I think, the way he tries to solve the issue shows the limits. For one, on the one hand, the pressure that the whole doctrine about ikhtilat al-ansab is receiving. I mean, how biomedical knowledge is pressing fiqh, issues like filiation, pregnancy, etc. And on the other hand, on the limits, because the punishment of, the criminalization of zina is based on the Quran and on the Hadith. And this is something we cannot deny. So, yes, it's a very delicate issue. He tries to deal the best he can, but to my view, unconvincingly.
We have to take in consideration that that fuqaha or jurists, they took their information from the women themselves. And they said in their books that these women are confident and we cannot deny their says. And it is some of says only, and nowadays we are trying as an intellectual in fiqh to filter these books according or taking in consideration the medical perspective, and but in same time in our courts we don't have any case raised in this matter, because any women know that the duration of pregnancy is 9 months, it is 38 weeks, and every woman know that. That's why we never heard about these matters. Even in the Islamic family laws, as I know, in Algeria, Malaysia, Qatar, Jordan, it's written. It's one of the articles in the Islamic family law that the duration of the minimum is 6 months and the maximum is 9 till 10 months. That's, yeah, only. Yeah, it's known for everybody. That's why my point that some people, they try to criticize fuqaha, but they have to criticize them in their period, not from with our knowledge or our information, because they don't know that information in that time. As she said about Ibn Arabi, she wants to illustrate the says of Maliki, and he is one of the imams of the doctrine. That's why he's only following his imam, but he cannot go beyond, because he don't has any information. He don't have any information in that time. This is my point.
Women's information or women's statements about duration of pregnancy and about their things were considered part of medicine in the modern. Was considered part of medicine, yes, or natural science or experience. In fact, there is a very famous statement, I think it's Ibn Rushd al-Hafid or Averroes, who says that he has quotes the testimony of a woman whom he knew, according to which pregnancy lasts 2 years. He appears to believe that, although he was a physician, and I assume he knew that pregnancy lasts 9 months. What I am trying to show is that, yes, nowadays legislation, but the question here is that contemporary family legislation in most countries where Muslims are majority, for example, Qatar or Morocco, is avowedly rooted in classical fiqh or in the Sharia. But as we no legislation is codified fiqh, this means that divergence of opinions has been removed. Divergence of opinions is, the soul of classical fiqh. So here I think it is legitimate it's okay to adapt to medicine, but it is also legitimate to say that contemporary legislation in reducing the maximum legal duration of pregnancy is not consequent with classical fiqh, or is not consequent with the Sharia. Maybe I'm not right, or someone has a different opinion, but it's not, I think the claim is, that's the question, that the authority of these codes relies on their being rooted in the Sharia or in fiqh, but they are not, they don't follow classical fiqh.
If I can mention for you the Algerian Islamic family law, the last article said whatever it is not included in between these articles, it's referred to Sharia, to Islamic Sharia, or any doctrine, even in Malaysia, the doctrine is Shafi'i. But whatever they find maslahah, the well-being, you can go on. You want to go from Shafi'i to Maliki or other doctrine, it's acceptable.
Welcome back to the final session. Since we're a bit behind schedule, which is 90% my fault, I'm going to be a little more ruthless in keeping questioners to time this time. So we will kick off with Ayman Shabana. Thank you very much.
Thank you very much. I think I just reiterate some of the points that I mentioned yesterday. Try not to bore you with the same exact presentation. But basically, the main points were, these categories that we kind of thought emerged from the interviews that we had with the medical professionals here in Qatar when we interviewed them regarding the moral and ethical questions surrounding the implementation of these technologies. And these are conceptualization, regulation, changes, implications of future prospects, and also gaps. So I kind of spoke a little bit about conceptualization yesterday, and a little bit also about regulation. And I didn't have a chance to speak about changes. So perhaps this is something I can elaborate a little bit more on. And what I found interesting is that these changes kind of coincide with the conceptualization, the sense that the most interesting changes that we could detect on the basis of these interviews were of two main sorts, what we call changes that have to do with perception, mainly of gender roles, vis-a-vis the reproductive process. So what that means is, or includes, among other things, is perception of infertility, that it is not the woman's fault. This is already acknowledged and recognized that man also has a role to play in that. And also perception of responsibility for the child's sex. Many professionals noted that increasingly males recognize that, especially those with higher education. So they don't blame women, for example, for these issues. In terms of practices, something also related to that is the attitude of males towards seeking infertility treatment. So many of them noted that actually husbands will now offer to have their semen checked. So in case they think or they doubt that there is a problem, they don't shy away from actually sometimes even coming forward and offering, rather than waiting for their wives or even the treating physician to make a request. So sometimes they take the initiative, and that came quite frequently in the interviews. Some, however, noted that sometimes that depends on the history of the relationship or the person. In this, especially in this region, polygamy is not infrequent. So in case, for example, someone was already married before and he had children within a preceding marriage, a previous marital relationship, then in these cases, husbands would be more reluctant to submit to tests or to have to be checked, for example, for. In terms of practices also, we talked a lot about how these reproductive technologies, genetic reproductive technologies, overall have been embraced. As far as the people we interviewed, they reported that they are seen in positive light. They are seen as important tools to help both individuals achieve their personal goals of course, having children, but also help states, as some presentations indicated yesterday, overcome some demographic issues, for example. So here, reproductive technologies are used not only to overcome infertility, but also to increase family size, and also to select for particular types of types. Here means gender, sex selection. But apart from these positive changes or consequences, some also noted the negative consequences that are associated with especially failed cycles of IVF, for example, taking into consideration how costly these cycles are and how taxing emotionally and also psychologically. So they talked about how people or how much people feel invested in this entire kind of process and procedures, and how much they are attached to the result or the outcome of these cycles. And when something wrong goes on or the cycle is not successful, then oftentimes this results in feelings of sadness and sometimes even depression. Speaking of gaps, something relates to that. People often highlighted the need for counseling, especially for people in these kinds of situations, that counseling has to be actually part of this whole that there is a need here for a therapist or a psychologist to be actually a full-time person or even more, just to meet the demand and the need. Sometimes many of them reported that they feel at loss. They don't know what to say, to couples who are in these kinds of situations. In terms of changes, there are increased inflated expectations. We talked about that. People expect answers to all questions. Sometimes professionals also feel that they don't have answers. Talked about how they are going to these IVF too soon, perhaps compared with other regions, other places. In light of the experiences of these professionals, at least, that we met. We talked also about the question of how these technologies may end up breaking cultural norms and transforming well-established models of the family. That didn't come up actually in the interviews, or at least was not that was highlighted. What was highlighted perhaps more was the positive impact of these technologies. Oftentimes the professionals said, yes, we are aware that that there could be far deeper consequences, things like designer babies, but that we don't encounter that in the real world. perhaps this is something that we need to think about long term, but in their experience, they didn't think that this was an issue, at least for the time being, that they had to worry about. Just felt that this is just something for the future generations, but not for this generation. Yeah, in terms of gaps, one of the most important points that was highlighted was the need for a unified policy at the national level to provide clearer guidelines on what's permissible, what's not permissible, what should be implemented, what should not be implemented, particularly when it comes to issues of such as sex selection, for example. So there was a great deal of flexibility, and that brings us this notion of agency, and room for different interpretations, depending on the availability of competing fatwas out there. So while some fatwas are a little bit more liberal, others are not that liberal. So what we saw in practice is that also professionals' attitude is not unanimous. I mean, different people actually are taking different positions. But the agreement was on, I don't think they have a choice here, is that they work within the legal. Legal here means the positive legal framework of the state or of the country. And because this is not regulated, then of course you can expect that there is some sort of flexibility or fluidity, you can call it, when it comes to procedures like sex selection. They also noted the importance of involvement of more stakeholders in the society. Many of them noted the importance of raising awareness about these issues through different social educational programs. So I would stop here. I would be happy to answer any questions you may have.
That's extremely interesting, and I realized that you had focused only on the doctors, on the practitioners.
Yes, correct.
Thank you. My question is, do you think if you had also interviewed couples who come there themselves, you might have had a different perspective from them? I know I'm asking you a difficult question, but you are knowledgeable, you know people, you know the culture.
This is a very good question. I always thought about that, but I wonder, I mean, when it comes to these ethical and moral questions, where these professionals are coming from. I mean, their insights reflects their interaction with their patients. So I would assume that it will be kind of similar. Of course, there will always be, you know, idiosyncratic kind of positions of each individual, especially when it comes to some issues like that are quite complex and complicated. But I would presume that it wouldn't depart much from this. Otherwise, it would have been reflected also in these interviews with the professionals. Because these professionals are not coming from outer space. I mean, they are interacting with patients, right? And whatever they said reflected their experience with patients, right? So the reason that we focused here is, as I mentioned yesterday, was just for convenience. We had a hard time actually recruiting patients, and we had very limited time. So
that's interesting, because I found when I interviewed people, because I worked on people outside the clinics as well, not those who came to the clinic. Either some of them I followed. It's some, you know, I knew outside. When they are in the clinic, they tell you one thing. When they go home and you do more in-depth research, a lot of other stories come out as well. This is, you know, sort of research.
This is very interesting, yeah.
That's why I think the knowledge of the culture and people beyond the atmosphere of the clinic. Yeah.
what I found speaking to people was that the two issues, particularly about the sex of the child and also male infertility or male responsibility, people often said, we were told that, we know that, but it doesn't matter. They still will maintain that it's the woman's fault. And I mean, that comes up again and again, and also the idea that it's, although they've kind of been told, there's a sense of, not so sure. So just in terms, I think that is true, that sometimes what happens in the clinic and what people are saying to the clinicians may be different once they get home or when they have a bit of time away from the experience.
I know one couple who had gone to one of the clinics in Tehran. Sorry, I can't switch this on. Thank you. The man was absolutely devoted to his wife, and we have got to have a child and I love her and all that. And when they, then the clinic interviewed them separately. And she was the infertile party. She confided in the male doctor and said, really, based on everything you have told me, I think it's better and cheaper for me to marry another woman rather than to pay for the cost of the treatment. And this, I mean, this is the sort of situations that, come up when you go into privacy of talking to them rather than, in the cold suddenly sort of interview. I don't know, it's just a thought.
No, this is a very valid point, and I think we will have to make this disclaimer that this is just based on, knowledge or ideas that were expressed by people. That does not include the perspectives of the patients. That's a very valid point.
I appreciate the fact that you're doing anthropology, because you're not trained as an anthropologist, but you actually did with your colleague, who's an anthropologist.
Yeah, of course, was my colleague. Yes.
Yeah,
well, as I said, I mean, one of the main benefits of this project was basically this kind of realization that I developed or gained, or that in order to say anything meaningful, you really need to have, this kind of rounded understanding. I mean, it's not enough to read the fatwas or fiqh or even laws or policies, but also you need to listen to people and how they struggle with these issues in the real world.
Yeah, well, and I feel that way with the DNA testing. There needs to be a great anthropological study of the people who are using DNA testing in, now in Egypt and in Morocco and so forth. But anyway, back to yours. I have to say I've spent a lot of time talking with infertile men in the Middle East from all over the region, and that has not been my conclusion that men are denying their male infertility. I mean, I don't know, maybe because IVF is newer in Qatar, but I don't know how old IVF is in Qatar, but it's been around for a while, right?
IVF, the assisted conception unit in Hamad, was established in 1993.
Been here a long time. Yeah. And the longer the technology is in a place, the more people realize that there's male infertility, there's female infertility, that there's ICSI for male infertility, that there's IVF. That in the region, that knowledge has been around for a very long time, and men are kind of manning up to their infertility. I mean, that is really true. I mean, I've really, really seen that change because they know that there's a technology, and so I do want to say that that's been my overarching finding, which I wrote in the book, The New Arab Man. It's mostly about male infertility. So if there's a difference here, if men are really still denying that they're infertile, somebody needs to do a good study of male infertility in Qatar. I guess that would be my thing. I was really wondering on a different issue, you mentioned there was a Northern European IVF physician in here, and I'm wondering about the character of the doctors, where they're coming from. I assume most of them are not from Qatar, or maybe some of them are, but just a little bit more on that. And also, are these clinics in Qatar dealing with the overall population, not just, nationals or locals, but are South Asian couples coming to these clinics? I'd love to know a little bit more about the sort of population of the doctors, where they're from, and the population of the patients, if you had any information about that.
Yes, we met some Qatari doctors, but I think they were quite few. Most of the medical professionals we met from all over the place, from the Arab world, but also from Europe, So perhaps one or two Qatari physicians, but the rest were mixed expats, like Arabs and
Yeah, that was true in the UAE as well. I mean, there was one Emirati IVF physician, I think in the whole, there were 12 clinics, and so that's interesting in and of
And
itself.
the point about the Qatari physicians is that they are burdened with administrative work. So often they have more administrative duties or responsibilities. So often they are heads of departments or supervisors, but not that they don't practice, they do, but they often also emphasize that the difficulty of balancing, admin work with clinical work.
And what about the patients? Are they, can anybody
In terms of the private clinics, yes, in Qatar here, they are open to everyone. Of course, it is, the distinction came in Hamad when it comes to difference between Qataris and Qataris. Qataris have more access, more privileges. But in the private sector, of course, it is, you pay for the service and it's open for whoever, wants the service and can pay, can afford it.
I think we probably have time for a couple more questions. Immaculata had her hand up, and it looks like Mohammed also wants to contribute. So let's start here.
Yeah,
and then if we have time, we can take one more.
One of the questions that you mentioned was that none of the physicians understood what they were doing as designer babies. You mentioned that?
No, what I meant is they were not super concerned about these kind
Right, because they didn't think that that's
they
what
didn't
they
think it's
were
practical
doing.
or that this is something that they are encountering on a daily basis.
Right.
They thought, but still, they thought they are important philosophical, moral issues for the future,
right?
But not for now. Because,
right, but that's it's an interesting that there has been some other studies that have asked similar questions to PGD to physicians who use PGD. And there was a recent one where they do a group of physicians, IVF, who use PGD from the Netherlands, and then the same questions with a group of PGD practitioners, international, working in North Europe, but an international community, community of doctors. And all of them have very different answers to a variety of questions, but they all agree on that point that they didn't see what they were doing, or they were not particularly concerned with this issue of designer babies. And one of the things that I was wondering is, was there then a question, asking them what is that they understood by designer babies, because I think one of the aspects is how we conceptualize what a design baby is, how we think about it. Because it seems to me that, choosing the sex of your baby or eliminating certain diseases and disabilities is already designing in some sense. But it's interesting that we tend to understand designer babies as, choosing the eye color and those kinds of things, which makes it then possible for clinicians to say, no, that's not a problem. That's not something that we are doing. Yeah.
Yeah, I think you make an interesting point about conceptualization of the concept itself, of the term designer baby, what it is, what it involves, yeah.
Two things. I think maybe Marcia might have mentioned this or somebody. It would be interesting to get a little more demographic information on the patient profile. Is it sort of representative of the overall population of Qatar, or is it because they're mainly private clinics that it might represent a more educated, more professional class of people, in which case we might not be able to generalize based on some of the attitudes mentioned here? Then the other thing that I was interested in related to a question or a comment made yesterday in the audience that said that although yes, in theory, the family balance fatwa is recognized here, they're actually very strict in applying it. So like there's an ethics committee, and that there was some family that said they had 5 daughters and they wanted to choose a son, and the ethics committee said, no, there's no reason to have a son. But then in your paper, you said that in the private clinics, if you have 3 daughters, then that's a good enough reason to have a son. So I'm curious, is there a disconnect? I mean, is the private sector completely like laissez-faire, Wild West, do what you want? If you can find a doctor to do it, you can do it? And if so, what's the percentage of the private sector IVFs versus the public sector IVFs?
Okay, let me just clarify, when you say demographic information, about patients you said, or about these professionals? Patients, okay. In the public sector at Hamad, they don't do any non-medical PGD or BGS or sex selection at all without going through that committee, right? Or even, for any other kind of bioethical issue or question, or like abortion, for example. So any case involving abortion has to go through the ethics committee first. In the private sector, definitely the perception or the impression that we got was that they are much more flexible when it comes to these issues. And sometimes we heard that was actually a reason why some people, Qataris, would choose to go actually to the private clinic, although they know they would pay, because they know that there is more flexibility there. But as I was trying to indicate as well when I was talking about, the notion of self-discipline and also the notion of religiosity, we met with people who had very strong sense of religion. I give the example of vasectomy, for example, while some people found that objectionable religiously and ethically, morally, others didn't find that quite objectionable. When it comes to sex selection, there was more flexibility. Some physicians already had, it sounds to me similar to the Iranian kind of context, where they already chose a fatwa and this is what they go by. And actually, I remember talking to one physician in that setting, and he said, okay, this is the fatwa that we go by, the fatwa by Qaradawi. He said this, and that, and this is what we implement. Others basically said, no, as long as this is not regulated by the state, there is no law against it, we do what the patient wants. So there was definitely more flexibility there.
Sure.
Yeah, that's really interesting. One of the things I was just wondering is you mentioned the issue around people coming in quite quickly, so within a year. Did the clinicians say frustrated with that? Would they tell people that, would you want to wait a little longer, or did they feel pressure that they then had to sort of allow the people to start the process of IVF?
I think most of them, especially I'm not saying that with any kind of negative, more female physicians were sympathetic, to this attitude on the part of Qatari women in particular, because they understand that they're coming because they are under pressure to reproduce, basically. So we had very interesting conversations with several of these physicians, and many of them, I could see that they're wearing the hat of a counselor and the hat of a kind of they wear more than one hat. They are physicians, but they are also counselor, right? So they talk to them, and then they kind of comfort them and say it's normal. The technical medical definition is 1 year. It's still too early to do anything, to intervene. It's better to wait. Some even said we entertain, all types of recipes, even traditional recipes, food, diet, prescriptions, as long as it doesn't involve invasive kind of procedures. So basically, they don't want to intervene too soon. So while most of them, they said we will not intervene before, the passage of 1 year, some said maybe after 6 months we will start kind of exploring, simple kind of procedures or medications, but not before that.
So really, what I was looking at is this. Very quickly, some of the differences that came out of looking at miscarriage experience in England amongst this particular group of women and what was happening here. And I was just suggesting, and I'm starting to sort of look at the way that control seems to be part of that, and how the idea of controlling, notions of control over your reproduction then can maybe lead to feelings of failure or anxiety when things don't necessarily work. And then I linked that with Motsa's story because her story really stuck with me, because she seemed, I mean, obviously there were similarities and differences within the settings, but also between the settings. And Motsa just got me thinking about how experience of miscarriage is potentially shifting in both places, and how women's experience of miscarriage may change in terms of a variety of forces, really. One of the cases, or two cases that I put in the paper, but I didn't get a chance to talk about yesterday, were the cases of Huda and Fatima, who were looking for or exploring ways that they might be able to choose having a son. And I just wanted to point out with that what happens is they're aware that there are options. At this time, I think they weren't able to do it in Qatar, so any kind of PGD, but there were thoughts about potentially going elsewhere. In Huda's case, she was told once she came back to Qatar that she wasn't eligible for it because she had 3 daughters, so she should just keep trying for a son and shouldn't necessarily use assisted reproductive technologies. So then there's a frustration. So there's choice, possibility, and then sort of limitations. And I was also just thinking about the demographic shifts that many papers spoke about the way that there's been this move towards smaller families, and how that also means that women and their partners are choosing a little bit more, or planning and maybe thinking about controlling their fertility, and just thinking about what that might do to the experience when plans go awry, really. And I think one of the other things that we've been hearing about over the past couple of days is how there's increased opportunities with newer and newer assisted reproductive technologies. So for example, as we've heard, some couples who weren't necessarily needing or requiring or feeling that they were requiring assisted reproductive technologies are now turning to them for sort of designing their families for whatever ways, potentially trying to have twins to maximize their efficiency in terms of reproduction, or choosing sons, for example. And then I sort of didn't get much time to talk about it, but I'm also thinking, and this very much links with Alex's paper, about how there's been a real focus on the family in Qatar and on parenting, and this kind of real worry and anxiety about that. And just thinking how a lot of that seems to be, in my readings of I mean, you've done much closer reading, but my reading of the government document seems to put a lot of pressure on women in terms of their role in motherhood and in caring for, nurturing, and sort of producing the next generation of Qatari citizens. So I was just trying to tie that in as well, so I'll stop there and open.
I very much enjoyed your paper. I just wanted to just some points to explore, or maybe. So, for instance, how you talked about how God's will was referred to in order to curtail responsibility in the case of Qatari women's experience with miscarriage. But I was wondering if you did not inquire the role of God when speaking about English interviewees. Maybe they didn't bring up God to the discussion, but in case they were believer, it would be interesting to see whether they might have seen God's influence as different. For instance, God punishing them as opposed to claiming that it's God's will. I also like how you showed that the Qatari context for normativity of miscarriage is disrupted by ARTs, because now there are methods to control reproduction, and it becomes then less God's will and more a matter of individual output, so investment. What I thought was maybe a bit missing is exploring the same trope for English women, because you started by contrasting their experiences with miscarriage, but then focused on ART with English interviewees. with the ARTs with the Qatari women. My guess would be that the transformation we are seeing in experiences of miscarriage in the case of Qatar due to the advent of ART could have started earlier in England, right? And just a last point regarding the different experiences of fertility issues. And looking at how for Qatari women it is context-based. So maybe looking at cases of Qatari women abroad. So if we kind of take them out of the context, so just to explore.
Just to say, I did ask the English women about golf, but it was always really interesting because I had to make sure I asked at the end of the interview because they pretty much never brought it up. And when I look at the sort of demographic, most of the women, I mean, I'd say 90% of the women said that they were atheist or agnostic. So again, and I just wanted to point out, it wasn't a representative sample, and I think that's, yeah, but I think it's a really interesting question.
Yeah, I have to say just in general, in the anthropology of reproduction, which is huge, it's a huge field, it's amazing how little there is on miscarriage, okay? So, I mean, I think it's just not a well-studied aspect of women's reproductive experience, and so I'm really glad that you've done this project on miscarriage, and especially the binational comparison is really interesting, so good on you. I'm gonna tell you, I think that you have in your title, I think you have 2 papers here, Susie.
You know, I always do that. I was thinking the same thing.
You've got 2 papers in here, yeah. I mean, you're doing like a Fairclothian, Gertinian paper here, because you're using their notion of anxious reproduction, okay? And you're showing that actually, with a question mark, actually for Qatari women, it's not anxious. The miscarriage thing is really not anxious, you know. But it's, you know, this isn't just, though, about miscarriage. And you've got the second paper in here just about the anxieties, the growing anxieties for these women in this country who are expected to be professional women now. They're educated, and then they can't devote enough time to their kids, but it is a separate issue. It's actually more like Alex's paper. And so I think you have to like make a decision or do a more seamless job of moving from one into the other. But I mean, they're both really interesting about Qatari women's lives, but the miscarriage and the maid, from miscarriages to maids didn't make a good connection for me. Okay, yeah. A little too much in one, yeah. But I think it's really interesting that there is all this anxiety around motherhood now, but not necessarily around miscarriage. Yeah.
Just a very quick question of all. Susie is editing a book on miscarriage, which is going to come into our series very soon. The other thing is what I was really interested in was your point about the fact that somebody having miscarriage here is a sign of fertility and not infertility. So I think you can perhaps turn that on its head, the whole understanding of what miscarriage is. I think it deserves a bit of elaboration because it's very interesting, because usually medicalized version of miscarriage is infertility, disability, whereas here it's viewed quite the opposite, you know. I think that is a concept worth developing.
And also, thank you, and I think that's very true. And also, what I found was that husbands very often said that to their wives as a comfort and a nurturing thing when they were sad about reminding them. Sorry, I keep doing that. And I think it's one way that men support their wives through these pregnancy losses by sort of saying, yes, absolutely.
Thank you so much, Susie. I personally have benefited a lot from your work, so I'm really glad that I have the opportunity also to meet and discuss. And there is something that I wanted, I mean, I think your approach in this paper and also in previous publications also struck me as something that I struggle with is sometimes we don't quite know exactly how the state views certain practices, right? And whether the state is supporting or not supporting them. And so I think you have written about consanguineous marriages also, and you've showed some of the tensions. And I think the claim you make in one of your articles is that the state is actually broadly supportive of these practices of consanguineous marriages. So I was just wondering whether you might elaborate a little bit, how do you see that support? How is that support expressed?
in terms of consanguineous marriages. Yeah, I mean, I think in terms of the premarital screening, so I think it's very contradictory, and I think you say that in your paper as well, and I think that's very true. When I was doing my research, there was a sense that we have people would say, I'm pleased we have premarital screening because it means that I can go ahead and marry a family member, and then we can have IVF if any problems are. So in that way, so I think it's confusing, and I think it's confusing for people in terms of whether it's supported, whether it's minimized in terms of its, yeah, and I think the other thing that tends to happen is that people would say, we're supported in marrying in the family, but just not as close. And people would say that quite often. Does that answer your question? Yes, exactly. So that the state is supporting marriage in the family, but not as close as first-degree cousins.
Yeah, one of the things that we've been sort of beating around the bush here, we haven't talked that much about, but it's really important for the Gulf, is this whole consanguineous marriage issue and just how it relates to genetic screening and so forth, because, I mean, in the region as a whole, the amount of cousin marriage is really quite high. I did a whole chapter on this. So it's the lowest in Lebanon, where it's something like 17% among Christians and higher among Muslims. And in parts of the Gulf and actually parts of Iran, it's 78% of people marry their cousins. And so, and in parts of the Gulf, it's well over 50%. And like it's going up, because of just how that relates to reprogenetic technologies. I mean, I think that's such an interesting, and I don't know if there are people in Qatar who are doing those kinds of studies about consanguinity and reproduction. Miscarriage, I mean, it must be related to miscarriage, yeah.
I know this is an ongoing concern here on the part, definitely on the part of the medical sector, that came up also in the interviews with many of them, and some of them were basically commenting on the burden, that this is placing on health facilities and health sector in general, especially in pediatric units, and some physicians were quite vocal in basically saying that something needs to be done. Particularly more awareness, in media, reaching out to the community, speaking about that attitudes needs to change. Although we have to keep in mind, I mean, there are different perspectives to this kind of issue of consuming. At first sight, it might look, quite straightforward and simple. There is a problem, you need to deal with it. But when you delve deeper, you know that there are rooted cultural kind of perceptions, but also in terms of interpretations, like religious interpretations of that. So you don't have one single view of that, while some like to see this as a practice that needs to change. Others say not, this is something that can be accommodated somehow, especially with these medical technologies that can give us useful information throughout the process, right? Starting from premarital genetic testing, and then during pregnancy, etc. IVF, of course, and PGS and PGD.
I was reminded, with the issue about the nanny that you have in the paper about the anxieties, the mothering and motherhood anxieties. We have a paper that is about to come up where we interview donors and egg donors and recipients on the issue of anonymity, various questions related to anonymity. But one of the things that came up, and again, this is a particular kind of population, New York, high class, IVF, context. But one of the issues that came up in this anxiety about disclosing that there was a donor and the characteristics of the donor and things like that, one of the mothers said, I have enough confusion with the nanny. So it's something interesting in these anxieties about, who is a mother and under what
On the consanguinity issue, I mean, I suppose that it's very difficult for young people to meet people outside of their sort of extended family. Is that the main reason why there's a high incidence of cousin marriage? That's just
There are other reasons too, yeah. It's like to keep the lineage, to keep the close, to stay in your family. It's considered to be more protected.
No, but so is there like
The family members say in terms of, because if you marry your child to a stranger, then you lose contact with them. You don't know that they are going to be comfortable in a familiar environment.
so like people block marriages outside of the extended family, or as opposed to, you know, people end up wanting to marry their cousins because those are the ones that are available?
Well, I think the thing is sort of the first, the obvious choice would be a cousin or second cousin. A lot of it is, people said quite often that it had a lot to do with the fact that, they wanted to make sure that their daughter was comfortable, wasn't in a strange environment, that the sort of customs and traditions were familiar, and that so that the match would be better. A lot of it was that we're trying to create a happy marriage and a long-lasting marriage. So, I mean, there was a lot, I'm sure, in terms of a lot of research is done about finding the best person to match your child.
Actor, sorry, they're jumping in this context. In Iran, people have gone back to cousin marriages because the rate of divorce is so high. People meet date on the internet, don't know each other. And now they think, well, at least we know who we're marrying.
Exactly.
And also they have, they are removing a lot of the problems with the genetic diseases by going to PGG and you know. So they are resolving the issue, but they have found a solution in going back to cousin marriages, consanguineous marriages.
Because it was in the scriptures, right? Allowed. I mean, yeah.
Doubt that it's allowed. I'm just wondering if it's more, you know, just because of other social conventions in terms of mixing and, you know, like lack of social opportunity, etc., that you end up marrying cousins because the only girls you see are your cousins, so you fall in love with your cousin, right? I mean, I'm just curious.
I think it's also linked to the anxiety generally about the outside and the fact that 90% of the population are not Qatari, and so I've written about it in terms of containing and a kind of trying to keep things and people safe really as well.
Thank you very much. I don't want to necessarily repeat what I said yesterday, but maybe I could tell you a little bit of the story why I came to be interested in this, in these issues, and perhaps briefly summarize some of the key points that I wanted to make. So I started working on the Ministry of Endowments and Islamic Affairs here, and they have it's a rather recent institution, actually, in Qatar. The Ministry of Endowments was only established in 1993, which is very late. But it has taken an active interest in Islamic law and family issues. So they've set up a website called Islam Web, which is today probably the largest online fatwa bank in the world, and contains, I think it's 300,000 fatwas, or it's a huge resource, and it's something that is a kind of.
Sorry, what is the Ministry of Endowments?
It's the Ministry of Islamic Affairs. Okay. Let's call it the Ministry of Islamic Affairs. Right, so Muslim states, post-colonial Muslim states have ministries of religious affairs that they call ministries of endowments, religious endowments, awqaf, and they kind of, so they build mosques, they finance religious staff, imams, They issue fatwas very often. They regulate the religious lives of the population, right? And so this ministry is in Qatar is set up relatively late, and it has it is nevertheless possible to study its activities in a number of ways. So they have a number of periodicals that they've been publishing and books that they've edited, but also they have this website that was set up in 1996 called Islam Web. And so it's like just 1 year after Al Jazeera, 1997, right? So it's very much part of the ways in which Qatar invested in media institutions under Sheikh Hamad bin Khalifa, rather than setting up more formal bodies. But unlike Al Jazeera, this website does not prominently advertise its connection to the Qatari state. So there might be a number of advantages in not doing that. So first of all, you will not be held accountable for any extremist interpretations that the muftis might disseminate online. In the context of in the aftermath of 9/11, that's a great advantage. But nevertheless, it's something that is quite prominent within the ministry. It occupies a whole floor of the ministry, and in its heyday, it won prizes in the Arab world. It's a very kind of user-friendly and sophisticated website. It's a portal that contains more than just fatwas, but the fatwas are an interesting source. And so there, in these fatwas, I was struck by two things. So if you talk to the muftis who issue these fatwas, they are very careful not to overstep political boundaries, right? So anything that is political is outside the scope. So they will not answer any question that might be politically sensitive, that might question or undermine Qatari state policies, right? This is what they tell you. I mean, they are aware of the limits, right? And so they are operating within like they make distinctions between what are religious issues that fall under the purview of the muftis, and then political questions that they leave to the state authorities. In a way, a typical distinction that you also find across the region in Saudi Arabia and elsewhere. And yet, although this boundary is very clearly polished when you speak to the muftis, on family issues, they speak with total freedom and in ways that often kind of undermine severely, or go against not only state laws, but also state policies and state laws. So, I mean, in Qatar, for example, you need to be 18 and 16 to get married, right? But if you ask the muftis in the ministry, there's no limit to any attempt to set limits or to set a minimum marriage age is illegitimate, right? And so they speak from a kind of standard Hanbali Wahhabi position in most cases on issues related to family that is kind of oblivious to state policy and state laws. Right? And so I wanted to think more carefully about how do the muftis then in the family issues relate to this wider discourse in Qatar about family cohesion. Family cohesion, I try to show, has become very important. There's a perception that the family is being disintegrated, and the state has put a lot of emphasis. And so what I realized is that there were some cases where there were clear oppositions, but in many instances, actually, it turned out to be quite difficult for me to pinpoint what exactly was the state policy on these particular issues, because it depended where I was looking, right? I mean, if I looked at some of the reports that were produced by the bureaucrats who work in the Ministry of Development Planning and Statistics, for example, right? And these are the people who produce like landmark documents such as the Qatar National Vision 2030, which you might have heard of. It's a very central document. We're all supposed to be contributing to it in some way here in Education City and beyond. It's one of these like modernizing visions that you find across the Gulf. And then it is articulated also within Qatar National Development Strategies. Right? Qatar National Development Strategies are are documents that seek to implement the objectives of the Qatar National Vision. And there was one in 2011, 2016, and the second one has just come out, 2018, 2022. And so in the first one, 2011, 2016, a big chunk of this document had to do with what they called family cohesion and women's empowerment. And this was a very important pillar of the Qatar National Vision. So it's kind of authorized. I mean, it's a document that was written by Sheikh Tamim, right, who was then not the Emir yet, the son of the Sheikh Hamad bin Khalifa. So it's like coming from very high up. But it's often, if you look more closely and if you ask questions, it's often written, these documents are often written by a host of international consultants, right, who think about Qatari society from a very distance. So they thematize development in Qatar in terms of like reconciling between tradition and modernity, right? That's the major challenge that they identify. And they think of Islam as something that is part of this tradition and needs to be kept, but it's not something that embeds or imbues daily life. So, I mean, like in these documents, Islam, I think, appears primarily as something that is worthy of protection, an endangered object worthy of protection and preservation, but not something that actually can be an engine for social change or development. And so that language struck me as really different from the discourses at Islam Web, but also more broadly in Qatari society, also the ways in which family law was drafted, right? Family law, which was codified only in 2006, is very much like, it remains tributary of the patriarchal frameworks of Islamic law. It differentiates between the roles of spouses, right? So women have to be obedient to their husbands, husbands have to be supportive of their women. So there's like, it's very much part of a more patriarchal discourse that is not so different from what you might also find in Islam Web. So I wanted to think more carefully about like how exactly does the state act in relation to family issues? How can I identify the ways in which the state tries to implement this family cohesion agenda that kind of cuts across these different bodies? And so I looked at, so I identified the law and the legislator, right? The legislative bodies of the state in the laws that have been passed as one area that allowed me to think about the way the state intervenes. I also wanted to look at the bureaucrats who work in these ministries, who are not, who are often, I think, not Qatari, but who nevertheless are producing these important policy documents, and they're also tracking and monitoring family life very carefully, right? So they're producing statistics and surveys that they're also not only collecting the data, but they're also organizing the data, and they're also interpreting the data, right? And I think there are important insights to be gained from the ways in which these bureaucrats then invoke both medical expertise and social scientific expertise in order to construct a certain vision of what family life should be like. And so I ended up with these three set of actors who deployed different kinds of argumentation. So one of the things that also struck me is that within these different bodies, the kinds of discourses that were being produced were also quite often overlapping. So science was not absent from the way muftis engage scientific questions or questions related to the family, but they would perhaps approach those scientific issues instrumentally. Islam was everywhere, actually. So in the Ministry of Public Health, they also understood, like they also invoked Islamic reasons in order to fight against consanguineous marriages, or in order to support premarital medical tests, but in a way that also differed starkly from the way the muftis did. So these medical doctors, or the people who write these visions of, what are they called? The Ministry of Public Health also has its own vision for a healthy society. And so there, Islam is Islam is construed in terms of broad principles, so they're not interested in like the kind of the norms, the specific norms that are articulated within the legal tradition, but they want to think about, they want to invoke Islam simply as a kind of in a utilitarian fashion, and so so I think Qatari society or the Qatari state offers a range of different discourses on family cohesion that I was interested in identifying and contrasting, and then situating those in relation to public debate. So one of the advantages for me to study family issues is that these are very present in public debates, right? So I mean, in the newspapers, but also on television, these are questions that are regularly debated. And so it gives you, I mean, in a country where public debate is not immediately visible, right? And you would struggle, for example, to find political criticism articulated directly in any of the local media, the family nevertheless allows a wide range of actors to contest modernizing projects of the state or participate in public debates in very diverse ways. So that's what I'm coming from, and those were the interests that drove my paper. I think I will stop here, maybe so if you have any questions.
I just have a quick question about the relationship of the muftis to the state. Don't they believe in the doctrine of obedience to the ruler? So if they're giving fatwas that would on their face be undermining the positive legal order, don't they find that they're not disturbed by that? They don't find that to be a problem, that they might be encouraging people to circumvent the public rules?
So I answer immediately, right? So if you ask them, they will, of course, say that they should not contest the regime, and they will provide even a religious argument for why they must remain apolitical. Right? But in practice, what happens is that when they are asked these questions, they don't even bother to look up the relevant Qatari laws. So the ministry itself is like really multicultural. And so the muftis who answer these questions, they come from Egypt, Saudi Arabia, Sudan, Mauritania, and their knowledge of Qatari law might be quite restricted. So they will sometimes refer to the law and tell you that you should not break the law, but very often they will simply ignore it and answer any particular question on the basis of the Islamic legal tradition. So the primary source, I mean, they're very careful. They don't want to go, they're not interested in being creative in the way they address the issues. So the first thing they do is that they go back to the Saudi scholars and think like, hey, are there any Saudi fatwas that we can use in order to answer these questions? I mean, there's Qatari muftis, I mean, there's historical figures that in Qatar that they don't really look at. And they basically draw on the Saudi doctrine. And in Saudi Arabia, the muftis would claim allegiance, right, or obedience to the ruler. Their fatwas often contradict state doctrine, right? But on questions like family or entertainment or other issues, right? Questions that the muftis themselves are confident that they fall under their purview of their work.
Modicum of disagreement or of challenge, well, maybe challenge is too much on the part of the muftis who are state muftis, like these ones, contributes to the legitimation of the state that abides by the Sharia. I mean, it adds to this image. I have to say that your paper is very complete. I first read the abstract and thought, well, okay, I will ask about, because, well, you show in a very comprehensive way the several underpinnings of the family institution in Qatar, the social, the political, the medical, scientific, the economic. I mean, it's your treatment of the situation of the family and of debates about the issues at stake is very broad. So I have to force a little bit my role as discussant. Yes, first I read your abstract. I thought, okay, I will ask about the rentier economic system, but I realized that, well, after reading your draft of your paper, I realized that you address this topic quite keenly as well, yes, and the other issues. I have the impression you talk about a plurality, and thank you very much in your presentation, the talk just you made. I think that you translated the content, your ideas to a language that I am more familiar with. Anyway, you talk of a plurality of normative registers that highlight overlapping and conflicting logics present in each normative register, and these overlapping and conflicting logics lead to the proliferation of intractable divergent opinions and to an intractable divergence or disconnect between state policies and religious discourse. I am right? And you see, so in your presentation, I have the impression, correct me if I am wrong, that you see this plurality and this overlapping of logics as something problematic. So first of all, I would like to ask you, why are the divergent positions, which are evident, intractable? Because yes, yesterday someone asked you about judicial practice and about, yes, how these issues affecting the family, for example, the situation of Qatari women married to non-nationals, etc., how these issues evolve or affect or are present in judicial cases or judicial practice. And you said that there is no much information about, about legal cases and their outcome. So I would like to know more about this intractability of because, yes, I understand what you mean. Plurality of normative sources and of approaches can be problematic, but if I think in the pre-modern societies and pre-modern legal and political systems, sometimes the plurality of sources of normative sources and of opinions contributes to a certain flexibility, whereas ending with conflicts between public policy, for example, and religious legal positions. If this conflict is solved through homogenization and unification for the sake of modernization, some observers have pointed out that this homogenization ends up by reasserting existing problems, existing social problems caused by certain legal and religious ideas. I don't know if I am explaining that clearly. And just one final point: who refuses to codify custom? Because I think it's very good that custom is not codified, but you mentioned at a certain point that legislators have refused to codify custom, or Sorry? I don't know if it was in your presentation or in the abstract, but this called my attention. And well,
Yeah, so I was worried that you might read from my abstract, because my abstract does not really reflect what I was also trying to do in the paper in terms of, I think I don't use intractability in the paper, and I'm not actually trying to problematize this agreement. I'm trying just to come up with a kind of analytical framework that allows me to understand what the positions are and why they diverge. And I think the points that you make about flexibility of traditional Islamic law are very well taken, and that's not something that I would like to problematize. I think in terms of I'm coming from also like within the anthropology of Islam or the anthropology of Islamic law, there is this idea that there's these three sources of normativity, right? There's the customary law, there's religious law, and there's state law, right? This is a kind of legal triangle that is kind of important in the literature. And I think that's important and interesting and useful. But what I wanted to show also, or what I want to think about is whether within these different normative registers, there might be logics that overlap, right? And so, for example, a certain kind of utilitarian reasoning that you might find expressed in calculations of genetic risk, for example, might also find its, and practiced within the medical institutions of Qatar, might also find the same kind of utilitarian reasoning might also be expressed sometimes by the muftis in their fatwas. They might adopt similar ways of thinking about these issues. And so I guess that was, especially in the abstract, I was trying to think about like whether there's a case study of these debates in Qatar would allow us to identify logics that actually cut across these different normative registers, right? So that was a kind of an attempt to contribute perhaps to the anthropology of law that became underdeveloped in the paper. In terms of customary norms, I think what I wanted to say, I mean, customary norms still play a role, and they are not codified, but they are part of legal practice, right? So one of the things that I hear in the course of some interviews that I've conducted is that there are, I mean, if you want to identify what are the issues where Islamic law might clash with customary norms, something that regularly comes up is the idea that here, according to customs, a cousin has the right to marry his cousin over other people, right? And so there are some cases, some of them are quite tragic actually, of cousins going to the judge and annulling the marriage of his cousin with someone else because he had not been previously consulted. And the judge sometimes, according to what people tell me, gives the cousin the right to annul the marriage, right? So there are, so customary norms, they're not codified, they're not part of the law as such, but nevertheless, there's some anecdotal evidence that shows that these are still being played. So that's one way. The other thing that where I mean, customary norms are sometimes invoked are in these, so they're not present in the text so much that I've looked at, but they are part of the public discussions and the religious and television talk shows that I describe. And there I think one of the talk shows that I analyzed in the paper is this talk show where there's this religious scholar, a judge, and a female consultant, right? And there, it's quite interesting. They are struggling to understand why divorce is rising in Qatar, when actually, on the face of it, family relations should be more stable, because as the religious scholar points out, and who's also the moderator of the discussion points out, today the couples know each other before they marry. It's not like in our time when we married strangers, which is like we met our partners the day we got married, right? And yet marital links are much more fragile, even though couples know each other before they get married, and also they exercise consent in a more active manner. So this is a puzzle, right? This is a puzzle that the religious scholar, male religious scholars, struggle to understand within the kind of youth practices of his day. So there's a kind of generational dynamic here too. And so the debate, I think, is interesting because then clearly these invocations of how things used to be done carry no normative value. So there's in the debate, these are completely sidelined. So there's just like this understanding that things have changed, and now you need to know your husband or your wife, and you need to investigate what he did or she did in the previous 2 decades before marriage, and you need to, because there's a lot of weight attached to family stability also, right? And that requires all these other things, right? So I think Qatari, in relation to family issues, Qatari culture does not carry a lot of normative weight, and this, I think, is I mean, it's kind of in contradiction with the ways in which the state actually and public discourse usually construes Qatari culture as something worthy of protection. I think in family relations, it doesn't carry a lot of normativity, perhaps for good reasons, as you say. Perhaps it allows for a different kind of family structure, one that is more in line with modern understandings and expectations regarding gender roles and so on.
It's just so interesting to me because if you look at Qatar from the outside, there's this famous Sheikha Moza who, was a woman, really out in the forefront trying to sort of promote women's issues and sort of education for women to make Qatari women, dynamic women. And so you hear that from the outside. And so I find it so interesting in your paper and in Susie's that inside there's a moral panic going on. It's a moral panic, right, about the family. And in a way, it's sort of a reflection that, women are getting educated like at Georgetown, University, and young women are taking their places in professional society and so forth. And it seems like it's very interesting. So women are doing these things which they've sort of been promoted to do in this country, but then there's the concern about the fact that they're not reproducing like they should, the fact that they're divorcing and maybe women are initiating divorces, the fact that maybe they're not marrying their cousins like they used to. I think it's really interesting. In a way, you've got sort of two different discourses going on. The one about women rising, and then I wonder about how much the moral panic sort of redounds on the shoulders of those women who are sort of not doing what they're expected to do. Just a thought and a comment.
Answer. I know. I think so. Sheikha Moza represents, I think, one strand, and so she's been very active in this Supreme Council for Family Affairs that was set up, that has been disbanded, and so there's a bit of a pushback against this modernizing vision of like women's empowerment. So I said that women's empowerment featured very prominently in the first National Development Strategy, 2011-2016. It has totally disappeared from the second one.
Kind of X'd out of the picture, is that what you're saying?
No, I think there's she has a support within Qatari society, but there's also a little bit of pushback. And what is interesting about the Qatari state and the dynamics of rentier states, perhaps, is that the response is not to marginalize these dissenting voices. The response has been to incorporate them within the state apparatus. So even the more conservative voices who are not in favor of female emancipation, women's empowerment, who deploy a different language and who might be more conservative, they also become part of the state apparatus. They also become part of the, they set up institutions where alternative visions of family life are being offered. And I just want to push back a little bit against these are not simply like conservative versus progressive views, because I think even in the discourse of the religious scholars who operate from the Ministry of Islamic Affairs, there's a whole set of modern assumptions and transformations that have taken place also. They've also integrated this idea of the family as a pillar of society, and they want to think about the family in specific ways. And that has transformed, I think, the fatwas they issue on issues like divorce, for example, that is now very much problematized and condemned, whereas arguably you could say that in Islamic law, divorce was just okay, right? But there's also, I mean, interesting moves. I think the incorporation of this family cohesion into the religious discourse has also transformed the nature of the fatwa. So perhaps we need to think a little bit about the different positions in as more than simply a kind of politics of modernity that opposes conservatism against progressivism, but that allows for a whole set of nuanced positions to be articulated from within the state.
Thank you for these excellent papers and the excellent discussion. I'm going to turn things over to Ayman for concluding remarks.
But I think the only remaining item on the agenda is basically this discussion about the next steps. So I wanted basically to explore two main questions regarding the publication plan. First, whether you would be willing to participate in some sort of a collective joint publication project. Yes or no? If you want to opt out, it's completely up to you. And second, if yes, then do you have any ideas or preferences or thoughts that you would like to share with the group, since this would be a collective project? So perhaps we can start with the first question. If you'd like to opt out, no pressure. But again, you can tell me in person or in private if you're not comfortable. And then we can move to the following question.
Do you have any idea? Some guiding?
Yes. Well, the two options are obviously, I was talking to some people, earlier, are either a thematic journal issue or an edited volume. So these will be the options. And I was wondering if you have any particular preferences, and then.
I say this because I don't know how my paper would fit in, because I feel like my paper is very different than what everybody else is doing. But in any case, that's neither here nor there. If you want me, I'm happy to participate. But I would have a strong bias toward a thematic journal and a thematic peer-reviewed journal rather than a collected volume. I mean, my experience with collected volumes is they can take years to come out. And part of that sometimes is that the contributors sometimes are delayed, et cetera. But I think journal publications tend to be a lot more disciplined.
Okay,
so
well,
that would be my strong preference.
All right. Other people actually reiterated that, so I see more than one person already indicated their preference to a thematic journal issue. You had your hand up? You had a question or a comment? Yeah. You agree? I mean, you agree on that? Or? Okay. Do you have any particular ideas on?
Well, another thing to think about, I mean, everybody here looks pretty senior. So if nobody needs a peer-reviewed piece for tenure or promotion, why couldn't we just do it as an electronic publication, if you have some sort of project website or something, and then it could just be, I don't know, just make it more efficient.
Well, usually what happens after conferences is two things. Conference proceedings, usually these are, unofficial kind of, proceedings of the conference, but of course, in terms of tenure and promotion and things like that, I don't think they count much. And the more credible, more weighty kind of contribution usually comes in the form, number one, journal article or a monograph or an edited volume. But, I think, of course, that would require more hard work in order to produce a peer-reviewed kind of piece publication. But I think long-term, this is a more worthy kind of contribution, I think.
I agree that if there is going to be a publication, a journal is better than an edited volume. I agree with you on that. It seems to me that the papers are in two distinct categories in this presentation. One are more on Islamic sort of analysis and all that. The other ones are ethnographic, anthropological. And I wondered whether they should go into two separate things.
This is a very important point. And there are I think, two ways to deal with this. Either, as you suggest, pursue two kind of journals, or pursue a journal that is interdisciplinary that would be open to the possibility of incorporating these different kind of contributions. I mean,
yeah, but the job of the editor is to make sense and pull together all of these things. I think it would be very difficult to pull all this. Although there are some themes which run through.
yeah.
But
Well, the fact that it is coming as a result of a conference or an event, perhaps that can be a point to make. And then the other point would be I'm aware that papers here kind of follow different methodology, perhaps following the different disciplines people coming from. Of course, we have people in the room here who are coming from philosophy, anthropology, Islamic studies, Islamic law. But I think there's an argument here to be made that this project is interdisciplinary, and that the main focus is the theme of the structure of the family, with the goal of basically addressing it from different perspectives, employing different methodologies, and definitely there is hard work still needs to be done. I mean, trying to make this look as coherent as it can be. I mean, but still, I mean, but still, I mean, each contribution, I think, should enjoy or should have its some sort of integrity, what people actually wanted to do, and how, in terms of method and methodology.
obviously, people will have to rewrite and revise within the themes discussed here, so there will be some more coherence in the final versions, obviously. Yeah. But personally, because I've written so much about my topic, I don't want to repeat it because a lot of that information, if I am to contribute something, it will be quite short.
Well, that, of course, I mean, it really depends on, each person, how much. And
I'm just clearing my position.
Sure.
I'll just say that I talked to Ayman about this, but the one journal that I can think of that might be interested is the Journal of Religion and Health. There was a conference at University of Florida a few years back on issues in sort of Muslim health, and they did it rapidly, and it's a Springer publication. There's no payment for like open access or anything, and that's where we did the bioethical aftermath article, and it was a pretty painless and quick experience. So I have to say we had a good experience with them, and they seem to be interested in, and now they're constantly asking me to review papers, anything on Islam. So, and I'm not an Islamic, legal scholar, so I keep sending them to Ayman, But anyway,
thank you very much.
Yeah. But anyway, I'm just saying that they might be a sort of natural venue if you were interested.
Well, that would be one venue that we'd try to approach, but definitely we will try other venues as well. And of course, I'll be consulting with the group. I mean, throughout this process, keep you posted, on the journals that I approached, what kind of response I received. So my experience, I have experience with journals like Zygon, for example. My impression is that they would be open to the idea. I don't know, of course, whether they would accept it or not. I also have experience with, I know people in the room here are accomplished, published a lot, so I'm not saying that to brag or anything like that, but medicine, healthcare, and philosophy. So also I had experience with them, and my impression is that they would be open. So these are just examples, and we can explore also other options. We included even Hawa, who can think about that as
well. I do have to say, I agree with what Soraya is saying, is that there is a sort of disciplinary divide. I mean, the papers could be somehow sort of made sense of together, but they're, there's sort of papers on contemporary Qatar, there's, work on Islamic legal precedent. I mean, the papers are, it's great that I've enjoyed this interdisciplinary milieu, but the papers are somewhat different. I'm wondering if like some smaller, like a smaller special issue, and they're like what, there are 10 of us or something like that, which is probably a lot for
in the
a
past
special
also
issue.
I see some people like doing not necessarily an entire thematic issue, sometimes section, like these large,
Sections,
these
okay.
large journals, like Zygon, for example, sometimes they do a thematic section, right? So, yeah, I keep talking about this interdisciplinary dimension of this project. And yeah, at least this is what we can propose at this stage. If there is a need to divide papers and into different sections, or even pursue different journals, we'll do that. Although I would prefer if it will be possible to have all the papers in one platform or one venue.
I think it's been such a wonderful conference and so enjoyable, so enriching and everything. We owe it to Ayman to
thank you.
actually contribute.
No. My colleague also, Jeremy Kuhn, he has been part of this from the very beginning. So he is a partner, I would say. So thank you so much. And I would like to thank you all for coming. I know it has been, you're coming from very, far and distant places. So you must be, I really appreciate coming and participating and sharing. This is really great to me personally, to Georgetown and to Qatar. So thank you so much.